Good afternoon, everyone. My name is Ann Bittinger. I'm the owner of the Bittinger Law Firm. Thank you for joining us for our April webinar entitled, Uh-oh, an employee accessed records illegally and the tabloids are calling. Today's session will be a very practical session and will include an advanced level of knowledge. This is the latest in our monthly Uh-oh sessions, in which we provide education on subjects that we get calls about on a frequent basis here at the law firm. We try to address issues that are relevant to what we're doing here at the practice. You know, we would find that clients would give us a call and say, uh-oh, we're having these problems. And so we came up with the name for the Uh-oh series because we would find that clients, often physicians or company CEOs or practice administrators, would call us and say, uh-oh, we're having a problem, aren't we, Ann? So do you have a few minutes to discuss it? And then as we saw trends, we developed the Uh-oh series webinars. We also try to act in response to current events and things that are going on. As we will talk about in greater detail, the Office of Civil Rights of the Department of Health and Human Services, which enforces the HIPAA regulations, announced a few weeks ago that they are going to start aggressive audits of covered entities as well as business associates. So instead of responding to complaints as they have for the past decade or so, they're actually going to affirmatively go out and audit providers. So we're going to talk in depth about that current issue today. I believe I've muted all your lines. You might go ahead and mute them on your end too, just in case. And then if you have questions at the end of the presentation, I ask that you go ahead and email me or give me a call. So with that, let's go ahead and get started. We're going to talk about celebrities today. Let's start with Kim and Michael. And I'm going to talk kind of just about the facts of these cases. Not all of these were HIPAA enforced cases. Kim Kardashian, as I'm sure you all know, had a daughter named North, and when North was born, medical records were inappropriately accessed. This was at Cedars-Sinai out in California, and 6 people were fired over the breach. 14 different records were accessed at different times. Right on down the road at UCLA Medical Center, that facility was fined under state law $95,000, and this was many years ago, for allowing unauthorized employees to view a patient's medical records. Really it was a breach that really seemed to be targeting the files of Michael Jackson. Again, UCLA, you'd think they could get this right eventually, but you know, you can only do so much, I guess, is what they're thinking. UCLA paid $865,000 to settle a celebrity snooping case. This was a few years ago, too. So it was Britney Spears, Farah Fawcett, and Maria Shriver all alleged that hospital employees broke the law and reviewed their records without the patient's consent. And so this investigation got pretty big and went over the course of a few years. And the investigators actually found that they did this repeatedly and without a permissible reason over the course of 3 years. So we'll talk about what happens when a facility or a covered entity has years' worth of exposure. So an administrative specialist, interestingly enough, not a healthcare provider or clinical personnel, was fired in 2007 after she was, in specific, caught accessing Farah Fawcett's medical records. And, of course, she did it to sell it to the National Enquirer. It's not just the ladies. Apparently, snoops like to know about records of some men, too. This was at UCLA, and it involved an employee who got notice that he was going to be terminated for illegally accessing records. So what do you do when you get this notice? Of course, you go home and you snoop about your boss's medical records, right, along with those of the coworkers. That's the right thing to do, right? And then over the next 3 weeks, he continued to access the organization's electronic health record to view high-profile patients' records, including Drew, Arnold, Tom, and Leo. Last but not least, it's not just the TV and movie stars and the singers, it's also the athletes. And this was here one closer to home in Florida. New York Giants defensive end was, he alleged that ESPN and their reporter violated Florida state privacy law. And what ESPN and Adam allegedly did was to photograph his medical records, tweet them to 4 million followers. And this was after the football player had an amputation, and the Giants then pulled their $60 million contract. So as you can see, this kind of thing is very pervasive. And then last but not least, not just the athletes, the celebrities, let's move on to reality TV. This actually just happened this week. The Office of Civil Rights, that's the OCR, settled with New York Presbyterian Hospital. So there was this ABC television show, and they disclosed 2 patients' protected health information to the film crew and staff while they were filming. And they actually went to the extent of filming someone who was dying and someone else who was in significant distress, even after medical professionals urged the crew to stop. This is a pretty extreme case. According to the settlement, ABC did not obtain authorization from the patients. This is a little quirky in that, you know, the person accessing it was someone from the outside who wasn't really a business associate of the hospital. They're kind of in there doing their own thing. But for goodness sakes, they need HIPAA authorizations from everybody who's going to be on camera, right? So this was a $2.2 million settlement that was announced this week, and it requires New York Presbyterian to enter into a comprehensive corrective action plan that includes 2 years of monitoring. If you Google, and you can pull up this website here, there's actually 4 different hyperlinks on the website that includes the corrective action plan, so you can actually see the documents that folks have to sign when the Office of Civil Rights sort of tells them they have to go out and do their penance for the next 2 years. You can see the levels of requirements, the policies and procedures, and so forth. So what do we learn from this? I mean, it's not that frequent, I'm guessing, for you attendees on the webinar, that Kim Kardashian shows up in your office or your facility, right? Well, the fact of the matter is that here in Jacksonville, I have had instances with clients who have had celebrities, some television stars, and then you also have the issue of local celebrities who may or may not be politicians. The mayor, elected officials here in town, they kind of fall in these same categories, right? Certainly, if you know anything about Florida politics, I wonder if some Florida politicians' medical records might be as valuable as Kim Kardashian's. But regardless, this kind of thing happens all the time with celebrities. But the fact of the matter is that they happen all the time with Joe, Mary, Bob, and Susan, too. So the reason why I put together this spin on a HIPAA webinar was to try and, you know, inject some new life and some fun into a subject that we all seem to have our heads beaten about. But to kind of give some examples of how HIPAA violations happen. And then I'm also going to frame our analysis on what you can do on these hot issues that we're going to talk about in terms of protecting your practice proactively and getting ready for these audits that sound pretty imminent. What we've seen here is, you know, employees, for the most part, accessing medical records for personal gain. When it's Joe, Mary, Bob, and Susan, and not Farah Fawcett, typically what we're seeing is employees trying to get health information to get Social Security numbers to do identity theft, to steal the patient's identity and get credit or whatever. But also, you know, where it usually comes up to are sort of family law, girlfriend, boyfriend, ex-husband sort of situations. I get those calls pretty frequently. And then some of it is just kind of self-esteem stuff, like being nosy and wanting to get this information and have it. Some psychosis kind of things, I think, but kind of some weird stuff there. But those are usually the two drivers. We're going to talk about phase 2 of the OCR HIPAA Audit program. Those are the eminent audits that I just mentioned, how to prepare. I will say that I'm going to go pretty fast and at a pretty high level. I'm not going to go into the details of the HIPAA basics. So if you have any questions afterwards, feel free to drop me a line. And remember, what we talk about in the next 30 minutes or so, it applies to celebrities, but it also applies to each of your patients too. We are going to talk about Sally Superstar. I've put together a lovely fact pattern that a law school professor would probably be very proud of in terms of using it on a law school exam, because it contains a whole bunch of issues that we can talk about in terms of the legal requirements of HIPAA. So let's just run through our little facts. So instead of, you know, using Farah Fawcett's and Michael Jackson's case information, I kind of took from a lot of different ones and put this one together. So we have Sally Superstar, and she's seen in the clinic or admitted to a hospital. And later, after she comes in, her agent stops by to check on her. Sally, being a superstar, knows that she can call the privacy officer of the facility ahead of time and be seen under an assumed name or an alias. So she did do that ahead of time, and the facility did comply with that request. And we can talk more about how that works. But sure enough, a nurse recognizes her and figures out, you know, and accesses her alias record in the EMR, because the attending left it open in the nurse's station. So the nurse who accessed it had no reason to look at it, but it was there, it was open, the attending nurse walked away, so she took a look at it. Later, an IT support contractor who is very savvy later finds the real patient name. So he was able to see sort of how the alias system worked within the EMR and found out who she was. And so this savvy IT support contractor downloads the patient's record onto his personal iPad, which of course has no password, and he has access to the EHR of the facility with no password either. And then, sure enough, the iPad is later stolen. The physician walks into the treatment room and says out of the blue to Sally Superstar, "My daughter is a huge fan. Can I get an autograph?" The next day, the tabloids call the administrator and say, "We hear that Sally Superstar is a patient there. Can you confirm?" The patient had requested, before coming to the facility, a restriction on her information. She wanted to make sure that any HIV test results that she has are not sent to her insurance company. She pays cash for her services, and she asked that she be communicated with post-discharge via email only. Sally hits the roof after she hears that the tabloids knew that she was there, and she asks for proof from the facility of everyone who opened her records, and she wants all her records emailed to her. So this is when Anne gets the uh-oh call. So we're going to break this down. First of all, the question from the tabloids, is Sally Superstar there? And this is information really just as to the presence of the celebrity at the facility. When we're analyzing these questions, we look first at whether it's PHI. PHI stands for, of course, Protected Health Information. PHI is PHI if it identifies the individual or if the information is such that there's a reasonable basis to believe that it can be used to identify the individual, and it relates to the individual's past, present, or future physical or mental health condition, or the provision of health care to the individual, or past, present, or future payment for the provision of health care. So what that means is typically name in and of itself is not enough. So what makes this a good question here is that it's kind of in a way more than just her name. It's her name and her presence at the facility at that time. Is she there? Was she there? So to me, that relates to the provision of health care to the individual. They provided some sort of care to her, and if they confirm that indeed she was there. Might be a little bit strict of an interpretation, but that's what would be coming from the Bittinger Law Firm on that question. So let's step back, and you might ask, well, what about the facility directory? People can call in and say, my neighbor is here at your facility, can I get the room number, right? HIPAA has a specific rule on facility directories. It's okay to disclose whether someone is there, but the patient has to be given the opportunity to opt out of the listing. So one of the things, if you're making a little mental checklist or actual checklist about things that you all might need to do to prepare for a HIPAA audit, one of the things is, what about your facility directory? It's just a prime open door way for somebody to access information. A lot of times the directory information is manned by a volunteer who may or may not have had his or her HIPAA training. So it'd be pretty easy to find out by calling and asking, right? Let's talk about whether the patient has been given the opportunity to opt out of the listing. The way we go about that is to put in the notice of privacy practices that we will, as a facility, give out your presence, that you are here, the fact of your presence, to any callers unless you let us know otherwise. So if you meet your notice of privacy practice requirements and you have in there the ability to opt out, then you're fine if she didn't opt out. Now, again, one of the things that makes this fact pattern really juicy is she said she wanted to be there under an alias. To me, that in and of itself is, I'm opting out from any directory, right? She's, even if she didn't use the plain language, I would like to opt out of the directory. She wants nobody to know that she's there. So the way the alias works is this. Most EMRs have an ability for you to give a record or a patient name an alias, and then in sort of a backdoor, very protected sort of way, keep that patient's name recorded, name, social security number, any billing information, so on and so forth. It's a fairly routine thing to do. Depending on your type of practice, you might have patients wanting more discretion than not, or depending on the unit of the facility, people wanting more discretion than not. But that's usually how it works. In the olden days, pre-EMR, what we would do is actually just, to the degree possible, and how we would usually do this is in the legal department of the hospital, have the medical records stored there, and a link up or sort of a matching ability kept in a locked case in the legal department or in the CEO's office, and then all of the records are under a different name. So that's kind of how that usually works. So remember that notice of privacy practices, which is another thing that we can audit, they must be provided to the patient, and the notice itself must specify that the covered entity, CE is covered entity, will use and disclose the patient's PHI. So you want to make sure that if you are a facility and you have a directory, that the directory is disclosed in the notice of privacy practices, and that it says that the patient has an opportunity to opt out. Now, when it comes to patient names, I always get a question about what about the patient check-in sheets? And I believe that the fantastic technology of adhesive strips on the sign-in sheet have really put this problem to rest. Most physician practices or outpatient check-in sites at the window have the sheets on the counter where you can actually peel up the patient's name once they checked in and then put it on their checked-in sheet that's on the other side of that fantastically HIPAA compliant window, right? Those are fine. Even not having the adhesives is okay. So if you want to buy a notebook at Target for 99 cents and put it out at your check-in window, you can. However, you need to be careful about what it is that you're asking for. Reason for visit is not a good thing to write at the header of the notebook. Name, new patient, time of visit, attending doctor, that sort of thing. Also be very careful if you have a check-in in a location that it's pretty clear what they're there for. This happens rarely, but I have had this situation before where there was kind of the main check-in and then there was this very obnoxious other check-in for other things where it was pretty obvious what you were being tested for there. So be careful about that kind of thing. Even though the check-in sheet itself didn't ask for the reason, the sign above the window made it pretty obvious. So in terms of whether anyone is being treated at a facility or a practice or is a patient, these are kind of the rules that we apply in the analysis that we would do. Let's move on to employees who can access Sally Superstar's record. Okay, this is really the big deal here. In all of the celebrity cases that I had from at the beginning, the Drew Barrymore, the Arnold, the Maria, that sort of a thing. I guess we did have some politicians there between Arnold and his wife Maria when it came to California politics. Talking about what employees can access Sally Superstar's records. The first thing that we kind of ask is, is the information being accessed for a TPO purpose? And those experienced HIPAA gurus on the call know exactly what TPO is, right? Treatment, payment, or healthcare operations. TPO is the main exception to the main rule in HIPAA, which is a prohibition against not only disclosing but using PHI, protected health information. So is the nurse who's not treating the patient from our Sally Superstar fact pattern, is she accessing the information for treatment, payment, or healthcare operations? No, she's snooping. There's no snoop in TPO. When she does that, she's actually violating HIPAA. So that's a pretty easy one there. Usually it's perhaps not quite that black and white. The question that we have to ask is it incident to a permitted use or disclosure? And if it is, if it's just kind of an incidental use, as long as the provider has adopted reasonable safeguards as required by the privacy rule, and the information is being shared is limited to the minimum necessary, then it's okay for her to access it. Like let's say somebody in housekeeping wanted to see if she was discharged. She probably doesn't need to access the entire medical record before she knows if it's okay to go and clean the room. But if she did, that's kind of incident to her treatment, so perhaps it's okay. But here's the key, and this is something that I think that the Office of Civil Rights is specifically going to look at, and that is tiered access. Reasonable safeguards in terms of employee access is this. Do your employees, every one of your employees, have access to everything in your EMR? That might be appropriate for a small provider where the employees are wearing many different hats. However, in a big hospital, in a small hospital, in a big practice, there has to be tiered access. And a decent EMR makes this process easy. sometimes from an operational standpoint where you do have different employees who are sharing different tasks, writing the parameters of what they have access to can be difficult. But tiered access, meaning if you are in accounts receivable, perhaps you do not need access to the entire medical record, those kind of things. Let's jump down to Workforce Security Standard 3. Implementing policies and procedures to ensure that members who do not have authorized access are actually prevented from accessing EPHI. The OCR wants to see that you've gone through sort of an internal self-analysis, an authorization process for determining whether a particular workforce member has the right to carry out a certain activity, designating different accounts types, conditions for groups, and roles for membership. Your in-house counsel at your facility likely does not need access to everyone's electronic medical records. So the fact that you've kind of gone through by category, by type, by silo, and said these people need full access, these people need access just to this, that sort of thing is what they want to see. And then what we also want to have is prohibitions in policies and procedures that tell employees that they can't access things if they're not using it for their job. We usually like to couple those with confidentiality agreements that the employees actually sign to acknowledge that they know that they're not supposed to be snooping. And the best way to prevent this is to terminate employees that violate it. I want to touch base real quick and go back up to the minimum necessary standard. It's kind of tied into, at least conceptually, the same access parameters that I just spoke about. Basically, the covered entity must make reasonable efforts to limit PHI to the minimum necessary to accomplish the intended purpose of the use of information. Keep in mind, though, that that does not apply to treatment. So in terms of clinical staff, you don't really have to be so concerned with minimum necessary, yet they still require some thinking about certain designated scopes of access. All right, let's move on and spot another issue here. Remember that IT support independent contractor who heard that that Sally Superstar was there and then broke the alias code and found her records. And then he downloaded them onto his iPad. And by the way, he got into their AMR by direct access, just by simply tapping the glass on his iPad. So, oh, I have a typo here I'm seeing. It's BAs are subject to HIPAA privacy and security rules. Let's scratch out not there. BAs are subject to the HIPAA privacy and security rules, just like covered entities. Everything now, this was after the implementation of the high-tech rule in 2013, your business associates have to do everything that you have to do in terms of policies and procedures in order to protect the PHI that they get from you. So my first question, if I got the uh-oh call and we were talking about this IT support guy, or God forbid I'm the attorney for the employer of the IT support company, the first thing I want to know is show me the business associate agreement. I'm assuming there is one. I want to see it. And then what is the allowed scope of access? What was the IT consultant supposed to be using the information for? One of the things that I see with a lot of clients is they'll throw out their business associate agreement, but it misses the spot in actually requiring what the uses and disclosures are that they can use. So if you have an IT support guy who's coming in to help you with updates and implementations to Allscripts, and he's messing around in some other program, that he's gone outside the scope of the authorization. So make sure when you're implementing your business associate agreements, don't just throw out your business associate agreement, the form template. Add a little paragraph in there or have it in there that either explains what the scope is, or what we usually do is say the scope is as described in the XYZ agreement, because you probably have an agreement with the IT company as to what they're doing, why, how, when, how long, who's doing it, that sort of a thing. So make sure your business associate agreement links up with that underlying contract. So what was the scope of access? Hopefully we know it from the business associate agreement, but if not, then I'll ask. The next thing I would want to know is, what do the business associates' policies and procedures say about this? What the heck? His iPad had no password on it, and then there was no password. He just had to tap to get access to the EHR. You know, that's insane. That is just get out the checkbook of the facility and write Office of Civil Rights in the to line, because you're going to pay some money in that situation. Certainly that had to be in violation of some policies and procedures. But if that wasn't a big enough uh-oh, an even bigger uh-oh would be that the IT contractor company had no policies and procedures about this. That would be the IT company taking out their checkbook and writing Office of Civil Rights in the to line. The question is, if this was something unilaterally, the facility or the business associate's responsibility, would the facility be responsible for the contractor's behavior? I have some bad news there. Even if the facility did everything fantastically, had great business associate terms, had great policies and procedures, if the contractor was acting as the facility's agent, which typically business associates are, right? Agency means you're doing something on behalf of the master, and that's the same standard for a business associate. They're doing something on behalf of the covered entity. Then the facility will be responsible. This, from a lawyer's standpoint, was probably the scariest aspect of the high-tech rule in 2013, because it really imputes liability to the covered entity just because the business associate is acting as an agent. So just to step back, if some jaws are dropping, it's similar from an agency theory standpoint to an employer and an employee. So for example, if a physician commits malpractice during a surgery, that liability can be imputed to the employer under an agency theory. The same thing can be imputed under a business associate relationship. So, if you have a business associate agreement, do you have something in there that says that the business associate is not acting as your agent and assumes all liability? Here's where a good lawyer comes into play. A lot of clients come to me and they say, oh yes, we have fantastic business associate agreements. We downloaded them straight from the Office of Civil Rights website, and it's really good. I'm sure it's exactly what the Office of Civil Rights would want. Indeed, the Office of Civil Rights would want you not to have a provision that puts all of the blame on the business associate. They would rather have two entities that they could ask to write checks to rather than just one, right? So a word to the wise, and we'll talk a little bit more about business associate provisions themselves, but if all you're using in your business associate agreement is what HIPAA requires you to use, you're actually really not only missing a real opportunity to protect your entity from HIPAA and other private exposure, you know, you're really missing the boat. It really is something that you really need to take a look at in order to protect yourself. So yes, in most cases, unless you've done something to protect yourself, the facility will be responsible for the contractor's behavior. And then will the contractor's employer be responsible for the contractor's behavior? If I was representing this gentleman, I would, or let's do it the other way. If I was representing the business associate, the company, the IT company, I would say this is a rogue employee who got this simply so that he could profit and sell this record to the National Enquirer. We are not responsible. The Office of Civil Rights would come back and say, let me see your policies and procedures, Mr. Business Associate, that where you had told this guy not to do this and trained him on HIPAA. I can tell you that this law firm is doing more work right now with business associate clients than we are with covered entity clients. It seems like, well, a lot of it is newer entrepreneurial companies are springing up with a lot of healthcare informatics and apps and lots of ways for providers to share information with different people now. So some of it's just technology, but some of it is that the new high-tech rules really, I think, scared a lot of business associates, and they're just now getting around to putting things in place. The last issue I wanted to talk about in terms of the business associate rules are that the business associate is required to notify the covered entity of a breach of unsecured PHI. So for those business associates here on our webinar today, know that if you have a lost laptop that had either protected health information or a really easy way to access it, that you need to let the company that's paying you to help with their IT stuff, that there's a breach. So that is something that is now required under the law. I'm going to switch now to focus a little bit more on security. As you may know, the HIPAA rules can be broken down into two silos, some of which overlap. The first silo is privacy, patients' right to access, the right to protect the information generally. But the big area that we're really doing most of our work on right now is security. So the fact that the EHR access was as easy as just a tap on this contractor's iPad is absolutely insane. Those of you who have done a lot of security work know that it's a little bit frustrating because the Office of Civil Rights doesn't just come out and say you have to have this level of firewall or this level of security. The mantra that we healthcare attorneys use is the requirements are scalable to the size and operations of the practice or the facility, right? So the key is in noodling, that legal term noodling. I want to see that you have noodled about what policies and procedures you have in place in terms of security protections. So we do a lot of writing memos to the file, and I'll say, me being a non-techie says to the techie people, explain to me why this level of firewall is okay when you could pay $1,000 more and get this level of protection. And then we document what the techies say. And that's part of the security management process. The Office of Civil Rights wants to see that covered entities and business associates have policies and procedures to prevent, to detect, to contain, and to correct security violations. This is found in Security Management Process Standard 4 in the implementation specs, if you have those handy on your monitor and are paging through right now. You're required to perform a risk assessment and then do some risk management. They really want to see a sanction policy. They really want to see that you fire people when they do the wrong thing. And believe it or not, they really do. And then an information system activity review. So what they want to see is that you have noodled on what you have, what you could have, documented why you're not spending the money on something better, and really just putting in policies and procedures to address that. I want to spend just a minute on mobile devices. We could spend a whole hour just talking about mobile devices and texting and what you can access just from a swipe of your iPad. What it seems to be the recommendation on the street right now are two levels of protection at least. It seems like my newer entrepreneurial companies are doing double authentication. So we're logging in with a password and then we're getting a code on our phone that we have to then enter in order to access the EMR. That is, I hate to say, becoming standard because I only see anecdotally what comes through my practice and kind of what I hear about. But that certainly seems to be the trend, specifically and particularly for mobile devices, just because they're a higher risk than a desktop. But speaking of desktops, let's go on to the next slide. The attending nurse left Sally Superstar's record open on a monitor. One of the components of a security risk assessment is an assessment of physical safeguards. So this is when I go through the office or the facility with my notebook, iPad, and I am looking for screensavers. I'm looking for whether desktops are located in public areas, and screensavers, auto log-offs. Believe it or not, you want in your HIPAA policies and procedures the time period in which a screensaver will kick into place. And you don't want that to have the physician be able to just go ahead and do that for, set it at 10 minutes in a hallway where patients are walking by. Those kind of things. So screensavers, privacy screens, these little things can really go far in terms of HIPAA compliance. So we want some policies and procedures on this, and we want some discipline if they are not complied with. Moving on, the stolen iPad. This really brings in the HIPAA issue of breach. Security management process in the HIPAA security regs, they want policies and procedures to prevent, detect, contain, and correct security violations, risk assessment, same thing, management, that sort of a thing. Let me, really on this slide, and it's a little repetitive, but the last point here, harm is irrelevant. One of the issues to be spotted in my fact pattern is, well, Anne, you didn't tell me if somebody actually swiped the iPad and accessed the EMR after the iPad was stolen. Doesn't matter. Doesn't matter. The fact that you have a lost iPad, a lost USB drive, a lost monitor, one of the biggest sort of lost cases is Blue Cross Blue Shield of Tennessee had a big storage facility where they put all the old monitors. Somebody broke in and stole a ton of monitors, the towers, where they put all the towers. And someone broke in and stole a bunch of the towers. Not a ton of proof that they were ever found or used, but it was at the time, I think, one of the biggest settlements ever by anybody in HIPAA was Blue Cross Blue Shield of Tennessee for stolen monitors from a storage. I keep saying monitors, forgive me. Stolen towers from a storage facility. Another scary thing from a legal standpoint from high tech was my second to the bottom statement here. An acquisition, access, use, or disclosure of PHI in a manner not permitted is presumed to be a breach unless the covered entity or BA can demonstrate that there's a low probability that PHI has been compromised. So they really kind of put the burden on the idea that if it's gone, it's a breach, even if nobody accessed it or used it. Moving on. The next issue we're going to spot in our Sally Superstar fact pattern is the agent stops by to check on her. This falls into the bigger category of what can you tell friends, family members, and other people who act like they're friends and family members. So this is actually a big-time exception to HIPAA. Sometimes in HIPAA we get down to the minutia of exceptions and standards, and it's section Q7A little b Roman I. This exception to HIPAA is right up there with the treatment, payment, and healthcare operations exception. So this is a big time, very clear. The government wants this exception to be complied with. And that is for disclosures to family and other caregivers. In the world that we're in currently about who can marry whom and who are family members, notice that the HIPAA language says, and other caregivers, very broad. No requirement that they have a familial or legal tie, provided that the individual, again, was given the opportunity to opt out. And you'll remember that we just talked about that in terms of the notice of privacy practices. So we address this issue also in the notice of privacy practices. Pull up your notice of privacy practices right now and see if it says that you're going to be giving disclosures to family members or other caregivers, and see if it provides an opportunity for them to opt out. So when the agent of Sally Superstar walks down the hall and walks up to the nurse's station and said, "So how's Sally doing?" Can the nurse say how Sally's doing? You know, my guess is that the agent is not a caregiver. Maybe in lots of different meanings, but I don't know if the agent would be a caregiver according to the meaning of this statute. Now, if it was something that, if the agent was somebody who really took care, if it was down on an authorization, if basically Sally said on her admissions paperwork that, yeah, you can talk to my agent, that's an authorization, so that's fine. But the nurse should probably say, "I'm sorry, you know, we're free to talk to family members and other caregivers. I know you're the agent. Not sure you're a caregiver. Can you help me with that?" Something like that, and kind of use best judgment, call a supervisor, that sort of thing, and maybe ask for the agent to wait and, you know, just say you can visit Sally directly when she's available, kind of a thing is probably how I would recommend that be handled. But that is the rule about who you can talk to about patients that are there unless the patient has opted out. So how about the lovely, poised physician walking into the treatment room, totally disregarding this patient's alias and saying, "Can I have an autograph?" Did this physician violate HIPAA by doing this? Probably not. Kind of depends. I mean, he probably definitely violated the facility's policy on use of alias. It was a really stupid thing to do, because that's the kind of thing that will make the celebrity or the person angry. I mean, they didn't even have an introduction. Obviously, this celebrity knows that somebody outside of that treatment room maybe said, "Yeah, that's Sally in there." Or maybe the physician, you know, listens to enough pop music with his daughter that he knew who Sally Superstar was. I don't know, but probably didn't violate HIPAA by asking for this. Probably violated state privacy law, depending on what he does with the information and who else has heard. So if he says that and all of the heads of all the techs that are in the room snap and look at her, and then they go off and, you know, say things, there might be some problems there, but probably those would fall under state privacy laws. But just his utterance to her is probably not in and of itself problematic, under HIPAA at least. Let's move on to Sally asking for a list of disclosures. Darn it, you know, facility, this is what Sally's saying, "Darn it, I can tell that you guys didn't protect my alias, and I want to know who you released all this information to. Why is Us Magazine calling you and asking if I'm here? Somebody breached my information." Every patient, not just superstars, have the right to an accounting of disclosures. When I'm doing HIPAA audits of clients, this is the area that, from a privacy standpoint, clients usually have the most questions. So what is an accounting of disclosures? Individuals have a right to ask for a list of disclosures made 6 years prior to the request. So it's a pretty, when you get down to it, in the real world, unless you have a lot of contractors and business associates that are really looking at your records and doing stuff for you, management companies, utilization review companies, outside companies, that kind of thing, there might not be that much on the list. You do not have to track, when you give records to the patient, you don't have to track incidental disclosures, and you don't have to track anything that's authorized. So if she signed a form and said, "I'd like my attorney to have a copy of my records," or whatever reason, if they have a signed authorization, you don't have to track that. But you do have to track business associates and disclosures to those. So sometimes what we do, What you do not do is keep a list of every patient and enter into every patient's chart that when ABC tech company comes in and has access to your EMR as they're helping you update it or implement a new version or do troubleshooting, you don't write that down in every patient's chart that you had at the time. That would be crazy. What you do is kind of keep a parallel list of all business associates and the time frames that they had potential access to the records. And so what you have to put in the disclosure is date of access is the best you can, a range is fine, the name of the recipient, the address, the description of the info, and then the purpose of the release. So let's say you hired the Bittinger Law Firm to help get a payer to pay for this patient's surgery. So I'm arguing with XYZ payer to pay, and of course I need the patient's medical record in order to make an argument of medical necessity or whatnot. So you would have to let this patient know in their, if they ask for an accounting of disclosures, that the Bittinger Law Firm had access to the records on these dates, or a copy was given on this date. You'd have to have our address, exactly what medical records were. Your entire treatment file would be sufficient. And then the purpose to facilitate payment, something like that. So that's the kind of stuff that you have to track. And then you have 30 days to respond to the request for the accounting. This is, again, an issue that a lot of covered entities have trouble with. Another fact, Sally had asked that her records be emailed to her. Does the covered entity, the facility, have to email them? This was another change in HITECH in 2013. They say now that the covered entity must provide access in electronic form or format if it's requested by the individual, if it's in readily producible format. So, if you don't have paper records and it's perhaps difficult for you to scan it and make it a PDF, then you probably can just mail a copy. Let me be clear, you don't have to. So the default is not electronic. It's only if the employee asks for it, okay? So if a patient requests a copy of EPHI and that says, yeah, just email it to my Gmail account, which is unencrypted, then the covered entity may send it, but they must advise the individual of the risk that the individual or that the info might be read by a third party. So this is kind of a crazy rule. It actually puts the burden on the covered entity to say, all right, we'll email it to you, but please know that this is that there's a risk it could be accessed by a third party. If you are in this process of implementing a system to email records to patients, make a default cover email that has this in there, so that language is always used and you don't even have to think about it. I think this is going to be less and less of an issue as the patient portals become more popular, but know that. And access via a web portal is one way that you can comply with a request for electronic PHI. Remember that you have only 30 days to respond and acknowledge the request. You should try and get it done in 30 days. If there's an explanation where it's going to take you more than the 30 days to respond, you have to give the response in 30 days that you need more than 30 days, and then you have another 30 days to actually get the record to Sally. Another issue, Sally asked for a restriction on the release of her records. What she did was specifically said, I don't want my HIV test results going to my payer. This is an issue that really makes the hair on the back of a lot of clients' necks stand up. This was new in 2013 in HITECH, so if it doesn't ring a bell, that's probably why. Covered entities now have to oblige the request of a patient who asks for a restriction. The covered entity can say, hey, this is only when you pay out of pocket. So you cannot come in and say, I don't want the information going to Blue Cross, and then I can't submit a bill to Blue Cross, right? So the patient has to pay cash for whatever it is that they want restricted. The problem really comes not at that transaction. Okay, the patient leaves, they pay cash, you're done. But a year later, a plaintiff's attorney who's suing Sally for whatever requests or subpoenas a copy of the record. Might not be the greatest example, but some other example where for some reason somebody requests records. Let's say utilization review. Let's say Blue Cross comes in and says, we're just looking at 50 random charts, and sure enough, Murphy's Law, they're going to pick Sally Superstars randomly, right? And you do not have it flagged for future purposes that this information is supposed to be kept confidential. Now, most good EMRs can do this with the flick of a switch. The problem is in letting your staff members know that it can be done with the flick of the switch and how to do it, and then how to get it if you need it. It can get dicey, and this is the hair on the back of the neck, so not just the inappropriate disclosure of PHI, but also, this is the question I get, but Ann, if I stick it in that back closet of our EMR, our physicians are never going to know where to find it. That's a legitimate concern. So the EMRs should have, or if you have still some paper records or however this is, some way of flagging that there is some record for the eyes of the physician or eyes of the practitioners only, and that they can see it, or that this is for the practices only and cannot be disclosed. So a big flashing orange beacon should come up and say there's more information, but it's only for practitioners. This is a dicey one. I don't think that the OCR will be policing this too much, but you can see it's if you don't follow it, it's a breach, and then you have a HIPAA breach on your hands. All right, I think that we have spotted just about every other issue. If you've spotted other issues in my Sally Superstar fact pattern, please email me, and I'll send you a gold star. I'm going to talk about enforcement. We're going a little over our time, but having some fun with this. And then I'm going to talk about the audits and what you can do. So if you don't think HIPAA is a big deal and they're not enforcing it, okay, this happened on yesterday and the day before. I mean, crazy. Just this week. We talked about the New York Presbyterian case. That was the reality TV show. $2.2 million settlement. Another settlement. Notice that these are cases that are being settled, which usually means that they're going to be too expensive, or that maybe the practice really did something wrong, and so they just go ahead and settle it. This is just a run-of-the-mill regular orthopedic practice. This isn't some huge payer or some crazy vendor or, ABC or CBS, whichever it was, filming a reality TV show. This is a group of regular orthopedic surgeons at this clinic here. They agreed to pay $750,000 to the Office of Civil Rights, and they agreed to enter into a corrective action plan. What happened here was so easy to have prevented. One of the things we do, and I'll talk about this in just a minute, one of the first things we do is a business associate assessment when we go into a practice. I want to know who all your business associates are, and I want to see the business associate agreement. If they would have had a business associate agreement with the vendor who had access to x-rays that contained PHI, this $750,000 would be going into hiring more staff and buying new equipment at their practice. But instead, it's going to the Office of Civil Rights. That's just this week. Keep in mind that not only the Department of Health and Human Services, Office of Civil Rights, but now the State Attorney General can sue on behalf of patients directly. I'm surprised Pam Bondi hasn't done this yet, but my guess is that she will. Also in high tech, the rules changed in terms of the direction in the law to the government. The direction in the law to the Office of Civil Rights now is that you have to do an investigation if a complaint review, a complaint or compliance review indicates a possible violation due to willful neglect. So what's an example of willful neglect? Screensavers that don't pop up that are in public areas, iPads that don't have dual levels of control, or at least decent levels of control. Those kind of things would give rise to willful neglect, and if that's in a complaint that the Office of Civil Rights gets, then the Office of Civil Rights has to investigate you. How do you then counter the argument that you were willfully neglecting your HIPAA duties? You have proof that you have done a professional HIPAA audit. Okay, take a deep breath here. The HIPAA penalties. HITEChed up the ante for violations of HIPAA. The old range was from $100 per violation to 25 grand. Now the top end is 1.5 million. And you can see that for the different categories, the maximum is 1.5 million for all of them, even if you didn't know that there was a problem. And so you can see there's different levels of intent here. And for the low end, the per violation amounts increase as you get more willful. So if you can counter an argument of willful neglect, you go from $10,000 for a violation down to $1,000. So let's say you had 2 or 3 violations and you paid for a law firm to do a security and privacy assessment such that you can show that you didn't willfully neglect. You just paid for your violation or the assessment right there. You know what I mean? But if you look at the exposure here, the investment in having someone come in and do an audit and do the documents right for you is completely worth it. The audits that the OCR just came out with are what they call phase 2 of their audit program. They are reviewing policies and procedures of covered entities and business associates. They want to see your HIPAA program. If you can't put your finger on it right now, that's a problem. If you haven't updated it in 5 or 10 years, or even since 2013 when HITECH came out, that's a problem. They did say that the audits will be primarily desk audits, meaning that they're going to ask you to email and mail things to them, and they're going to review them. They're not going to show up on site. But they do say that some on-site audits will be conducted. They're sending a questionnaire to get some information. They do say that entities that don't respond will probably still be selected for a review. Keep in mind that this is the OCR of the Department of Health and Human Services, which is Medicare, so they kind of know who you are and what you're doing. So even if you don't respond to this lovely letter, they'll probably, have an opportunity to find you. Some of you may have received this. I've heard that some of these have gone out, but I'm not sure that they really have. But this is the form letter. They say this is what the letter is going to look like that we're going to email you. And initially, they're just asking for name and contact information so that they can be sure that they have a good database to send the next phase of questions about send me your policies and procedures on this and that. Okay. OCR will be asking covered entity auditees to identify their business associates. So the Bittinger Law Firm encourages you to make sure that you have a list of your business associates and their contact information so that you're not putting it together when you get the lovely email from the OCR. So what can you do to prepare for these phase 2 audits? Do a test audit. The best way to prepare for a run is to do practice runs. The best way to prepare for a game is to go to practice. The best thing that you can do is audit yourself before the government comes in and audits you. The HIPAA police want to see that you've done a security risk assessment for all issues related to EPHI. We do a ton of security risk assessments here. Let me pause for a moment. Many IT vendors are going to covered entities and saying, we will do security risk assessments for you. So the IT companies go in and they ping this and they ping that and they recommend that you get this and they recommend that you get that. And then this would happen with, especially because meaningful use had a requirement in it that you have a security risk assessment done. So I would say, okay, so now you're filling out, client, you're filling out your meaningful use attestation, and the government is asking for a copy of your security risk assessment. Can I see that? Oh, well, number one, ABC security, IT security company came in and they did an audit. Okay. All right. And where's the results of that audit? Well, I can probably get you the invoice. Okay, my friends, that is not a security risk assessment. A security risk assessment is really done in tandem with IT folks and attorneys who document that the specific criteria within the security rule are met. And perhaps not only that they're met, but it includes an explanation of the scalability. So perhaps you're not encrypting all your emails. Why aren't you? Because you're a two-person practice? Okay, that's the kind of thing that we put in a security risk assessment. We explain that. You know, pinging your server 5 times once a week is not a security risk assessment. So be careful what you're buying and what some IT companies might be saying that they're selling. Another word to the wise on that is no IT company is HIPAA certified. No covered entity is HIPAA certified. No business associate is HIPAA certified. There's no good housekeeping seal of approval for HIPAA. So people who are saying that are kind of just throwing it out there. If they say that, you need to ask more specifics. Well, what does that mean? What criteria do you have? What classes have you been to? What does that mean? But the government does not certify anybody as HIPAA compliant. So our recommendation, and clients who have us managing their HIPAA privacy and security programs have us go in annually and do updated security risk assessments. It's really easy once the first one's done. We actually physically go in and we look at monitors and screens and say, why is this out in the open like this? So we do some brick and mortar assessments. We ask, why is your server kept under your hot water heater? Things like that that are more physical in nature. And then we also kind of match up all of the security, more of the IT protection. So it includes all of that. Security is a physical component too. Our recommendation is that if you have kind of piecemealed your HIPAA compliance efforts to date, and you haven't, especially if you haven't done a comprehensive review since 2013 when HITECH came out, you probably need a comprehensive HIPAA compliance assessment, and then also the creation of a dashboard or work plan for you to self-monitor HIPAA issues into the next year. So this is our approach on HIPAA audit and assessments, and this is what we're recommending to our clients that they do in preparation for the OCR Phase 2 audits. Have us review your existing HIPAA program. Give us your policies and procedures, and let's make sure that they're up to date. That's kind of silo number 1. Silo number 2 is we want to see all your forms. We want to see your notice of privacy practices. We want to see your authorization forms, all of those. We want to review those and get those up to date. Now, Silo 1 and Silo 2 are not done very well unless we do interviews with key staff to sort of question. We kind of poke you with a stick. Is this what you're telling me? Well, we kind of challenge you and play devil's advocate a little bit. And so we do interviews with key staff to identify vulnerabilities and to ensure that actions match policies and procedures. One thing that I've done recently that was kind of outside of the box is I went in and with key leaders who are on the front lines of the provision of healthcare and the provision of healthcare information, we started off with HIPAA training. And you might see here in our list we have training last. Well, why would you start with training? It's amazing what you do. If you're up at the podium and you're saying this is the rule, you can see on the audience faces the degree of HIPAA compliance at the practice because they don't usually have their poker faces on. And so when we do that training of the key individuals at the start, that's when the uh-ohs come. Uh-oh, So I have them write down concerns, why they're listening, and then what we do when we have our audit is that gives us a great area to start and target. It's kind of like a path that we can go on. You don't think you're doing this right? That's great. We can help you with that. So we do those interviews, or we do training maybe at the beginning. Silo number 4 is business associates. As you can see from the Raleigh orthopedic case and tons of them, if you go to the Office of Civil Rights website, business associates are high risk, high risk. So have you identified them? Are business associate agreements signed? Are your business associate requirements all in there? And then are the additional provisions in there? When one settlement came out recently, I emailed a bunch of clients and I said, this is a good example of why you require in your business associate agreements that your business associates have HIPAA insurance, because it was this huge amount that they had to settle, and you wanted to make sure that they had insurance for that, that sort of a thing. So there are lots of additional provisions. I could talk about business associates for another hour, so I'll move on. We also do a security risk assessment, which we just talked about. And we document compliance with the rules. We do training. And what does this cost? I don't think that this line is so much of an uh-oh, especially when you compare it to the chart from a few slides ago. You know, basically, to go in and do this right, it's about a $5,000 project for a small entity. Others, you know, depending on the sophistication, the practice size, what they're doing, is there research involved, how many divisions and departments, that kind of a thing. You know, you're looking up in a big consulting project sort of a fee. So I would definitely recommend that in some way, shape, or form, this be done for every covered entity and every business associate across the country, just to make the job of the OCR so much easier when they come in and audit you. So with that, we're going to sign off. You have here my email address and my phone number. I'd love to hear any other issues that were spotted that you saw and any questions that you have. And with that, I wish you a great afternoon and a great weekend. Thank you very much.